Probably the most powerful instinct as a parent is to protect our children. Parents work hard, sacrifice, and sometimes risk their own lives to protect their children. Most parents believe the government is there to help them protect their children too, but is that true? Take, for example, the case of Parents Protecting Our Children UA versus Eau Claire Area School District, Wisconsin. Parents Protecting, an association of parents, sued the Eau Claire Area School District to prevent them from enforcing guidelines that interfere with a parent's right to make decisions for their child. Both the district and circuit courts denied the parents, claiming that no child had yet been harmed by the school policy, and therefore they don't have a right to petition the government for a redress of their grievance. If a court can tell parents they are not allowed to protect their children until after someone is hurt, then who is? Because it's not the school district. So we'll discuss that next on the Constitution Study.
Neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here of the Constitution Study, where we read and study the Constitution. Teach our age and generation be free. I'm glad you could join me today. We're talking about protecting our kids, and it's one of those baser instincts that really tend to get people's attention. Now, I can point you to the article on the website, constitutionstudy.com, with all the links you can follow to double check my work, but I'm going to talk more about the website at the end of the episode. For now, let's take a look at this case and what the courts are saying about a parent's right to protect their children. There's been a lot of controversy over parents' rights lately, especially related to public schools. From the teaching of critical race theory to drag queen story hours, there have been situations where the relationships between the parents and the school district have become outright hostile. Since the 1932 case Meyer v. Nebraska, the Supreme Court has recognized the right of parents to direct the education of their children as being protected under the Due Process Clause of the 14th Amendment. This was reinforced by the 2000 case Troxel v. Granville, which stated, "The 14th Amendment's Due Process Clause has a substantive component that provides heightened protection against government interference with certain fundamental rights and liberty interests, including parents' fundamental right to make decisions concerning the care, custody, and control of their children." However, when Parents Protecting Our Children sued the Eau Claire School District for putting in place a policy that directly infringed on their right to make decisions concerning the care, custody, and control of their children, both the district and certain courts punted the question, claiming the parents did not have standing. We start with the policy in question. In 2021, the Eau Claire Area School District promulgated the Administrative Guidance for Gender Identity Support. The administrative guidance aims to foster inclusive and welcoming environments that are free from discrimination, harassment, and bullying, regardless of sex, sexual orientation, gender identity, or gender expression. To this end, the document provides guidelines for schools to follow to address the needs of transgender, non-binary, and/or gender nonconforming students. Like other schools, the Eau Claire School District finds itself in the middle of the transgender controversy. It therefore decides to put in place guidelines to help prevent discrimination, harassment, and bullying. I think that's a reasonable precaution for the school district to take and a laudable goal. Its unfortunate implementation, though, leaves a lot to be desired. The process envisioned by the administrative guidance recognizes that either students or parents may contact school officials with questions, concerns, or requests bearing on matters of student gender identity. By its terms, the guidance acknowledges the delicacy and sensitivity of these matters, including the possibility that some students might not be open at home for reasons that may include safety concerns or lack of acceptance. For that reason, school personnel should speak with the student first before discussing a student's gender nonconformity or transgender status with the student's parent or guardian. So far, so good. The school appears to want open communication between themselves and both the students and parents. I don't have a problem with the school talking with a student before discussing their gender nonconformity or transgender status with the parents, but the vision of inclusive and welcoming seems to quickly dissipate. In 2022, the school district prepared a template gender support plan. Like the administrative guidance, the support plan recognizes that circumstances may arise where parents are not involved in creating this plan, in which case the plan directs school officials that it shall be made clear to the student that this plan is a student record and will be released to parents when they request it. This disclosure commitment gives effect to the school district's acknowledgement that a support plan is not a privileged document between the student and the school district. The support plan may not be a privileged document, but how are parents supposed to know they can request it if they don't even know it exists? Speaking of parents, what is their view of this guidance? Parents Protecting Our Children is an unincorporated association of parents whose children attend schools within the Eau Claire area school district. Parents Protecting worries that the administrative guidance encourages the school district to leave parents in the dark if their children wish to explore their gender identity or begin to socially transition to a different gender at school. The association also fears that the school district will implement the guidance and related support plans in ways that effectively displace parental rights by making major life decisions for their children. In these ways, the organization sees the district's administrative guidance as sowing so much secrecy and mistrust between parents and their children as to offend principles of substantive due process and religious free exercise. So Parents Protecting sees two major issues with the Eau Claire guidance. First, it intentionally leaves parents in the dark about a major change in the child's life. Second, it effectively allows the school district to replace the parents in making such decisions. Now, both of these seemingly violate the parents' fundamental right to make decisions concerning the care, custody, and control of their children. Now, as stated in the court case, by its terms, the guidance acknowledges the delicacy and sensitivity of these matters, including the possibility that some students might not be open at home for reasons that might include safety concerns or lack of acceptance. For that reason, school personnel should speak with students before discussing a student's gender nonconformity or transition status with the student's parent or guardian. Notice the school district's position is not simply a question of the student's safety, but of acceptance. Simply because the parents do not accept the student's position does not give the state and the person of the school district the authority to overrule the parents. The parents have a right protected by the Constitution of the United States to make decisions for their children. Not only does the state not have the authority to overrule the parents simply because they think the decision is wrong, but the state has the burden of proof that the child's safety is at risk. If the school district has probable cause to believe the child's safety is at risk, shouldn't they show examples where the child's safety was put at risk? It should not be enough for the school district to merely say, we think the child's safety may be at risk, to override parental rights. So how did the courts come down on this question? The district court concluded that the association failed to allege any injury or risk of injury sufficient to establish standing under Article 3's case or controversy requirement. The district court said the Parents Protected failed to allege either an injury or risk of injury sufficient to establish standing under Article 3 of the Constitution, which states, "The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority. This case is a question of equity under the 14th Amendment." Seems to me between the actual language of Article 3 and the Supreme Court's decision in Troxel, there's an injury that should provide standing. Neither the administrative guidance nor the template support plan the district court determined mandated the exclusion of parents or guardians from discussions or decisions regarding a student's gender expression at school. The policies do not mandate the exclusion of parents, but establishes a process by which they can be excluded without probable cause. Although the school district claims that the support plan is not a privileged document, since the court's own record shows that the parents or guardians can access the plan, how are the parents supposed to know the plan exists if they're not told? It shall be made clear to the student that this plan is a student record and will be released to the parents when they request it. This places the decision of the student above the rights of the parent to control the child's upbringing. This is a direct violation of, and therefore an injury to, the parent's rights. From there, the district court emphasized that the complaint lacked any allegation that any member child had questioned their gender identity or otherwise sought guidance or support under the school district's policy, leaving the association unable to plead any withholding of information from parents. By this logic, if a threat to beat you up if you exercise your right to free speech, isn't injured until you're actually beat up. The school district has stated in writing that it will violate the rights of the parents by not giving them the information they need to guide the upbringing of the child. Isn't that like the school telling the child to play with a fork next to an open electric socket, then telling the parents they cannot intervene because the child hasn't actually electrocuted themselves yet? And just how are the parents supposed to know if the school district has a support plan if the district is withholding that information? In its final analysis, the district court viewed the alleged harm as dependent on a chain of possibilities too speculative to establish Article 3 standing. Now, since both the district and circuit courts agree that parents protecting does not have standing, it appears that removing any imagination is a requirement to become a federal judge. Was the school district required by the court to provide documentation of the use of either the administrative guidance or the support plan? Not only is the very idea that a school district could keep information about the health of a child away from the parents an injury to their rights, but what about the mental harms of continually lying to one's parents? Just how far will the school district go in support of their plan? Will it be limited to names, pronouns, and dress codes on school grounds? How about counseling or even treatment to assist in the transition? What are the long-term effects the parents would not be aware of? Could parents seek counseling for depression and other mood disorders that are commonly present in such transitions without being aware what other counseling the child is getting? Will parents seek medical treatment without being aware of all the medications the child may be taking? How can a parent give informed consent to any treatment if they are not informed about other treatments the child is receiving? In my mind, the only way the court could find the alleged harms too speculative to establish standing is willful ignorance. What can we logically conclude from the decision of these two courts? First, we need to admit that among the transgender policies schools have adopted, this is not the worst, not by far. While the Eau Claire School District does not mandate the keeping of information from parents, it certainly does facilitate it. By listing a lack of support as a justification for allowing students to refuse permission for school districts to share information with parents, they have replaced the parental right to oversee the upbringing of their children with the promotion of a political agenda. And the courts are going along with the same agenda. After all, if it found out the student started taking drugs, would the school not be legally required to notify the parents? What if the school found out the child had another mental disorder? Would the school be compelled to notify the parents? Then why not in this case? The answer is simple: the transgender agenda. The fact that the dangers this policy presents were beyond the imagination of the judges in these two courts says more about the agenda of these judges than the quality of parents protecting's case. If you are parents, I hope this case shows you that the school districts are not looking out for the safety of your child, or at least not as a first priority. It also appears that these courts are more interested in state power than citizens' rights. This is another example of why parents need to be more involved in their child's education, and especially in the school board. I have to wonder if members of Parents Protecting Our Children view running for and serving on the school board as one of the methods of protecting their children. If not, maybe it should be. Okay, so this is not the worst transgender policy a school has ever adopted. It's actually not that bad. It has one fatal fundamental flaw: the notification of parents. See, it's not hiding the information from the parents, but it's not telling the parents either. Don't parents have a right to know? After all, if the child suffered any other illness, any other disease, any other condition, the school would be required to tell the parents. Why not this one? Because it involves sex. It involves a transgender agenda. And right now, that agenda supersedes reason, logic, and the rule of law. I hope if you're a parent, this opened your eyes to maybe look at what your school is doing. Maybe get involved in the school board. Maybe run for office. Because remember, it was the school board that created this policy. Maybe if people from Parents Protecting had been involved in the board, this policy would never have been put forward, and this wouldn't have been a controversy. They're still our children. We need to take responsibility, even when the state tries to take that away. That only happens if we get engaged. And we're only going to get engaged if we know what our rights are, like John Jay told us. If you read and study the Constitution, you'll know when your rights are being violated, be the better prepared to defend and assert them. That's what we do here at Constitution Study. Check it out at constitutionstudy.com. Maybe ask a question or join a mailing list, but get involved, do something. Take the planning wizard, see what other tacks you may want to take moving forward. The point is, there are things we can do. What we have to do is stop thinking of the school district as another parent. They're not. They're there to help the parents, not to replace the parents. But that's not the attitude of many school boards and probably many administrators. They think the parents get in the way of the education rather than being the guiders of education. Again, the only way we stop it is if we work together. You don't have to fix the nation's schools. All you have to do is work to fix your school district. Start there. If you can make a difference in your school district, well, that protects your children and your neighbor's children. And then if other parents do the same thing, well, we start making a change. The important thing is we are not helpless. We're not without recourse. But we have to be brave enough to stand up and say something, knowing we're going to get called names, we're going to be yelled at. But what's more important, being called names or your children's future? For me, I know the answer. My children's future every time. I hope you'll join me in that thought, and I also hope you come back and join us here next time for the Constitution Study.